Hello and welcome. I am Deji. Now, there's one issue that many Nigerians have had their eyes on since last December, and that's the case of former Chief Justice of Nigeria, Walter Nkanu Onnoghen, who was then accused of falsely declaring his assets. Well, after 4 months of legal tussle now, Onnoghen has now been served his verdict by the Code of Conduct Tribunal. The former Chief Justice had earlier resigned his position as the country's top judge, but going by the judgment of the Code of Conduct Tribunal, that decision will not avail much for him. On Thursday, April the 18th, Danladi Umar, Code of Conduct of Tribunal chairman, now found Justice Onnoghen guilty of violating the provisions of the Code of Conduct Bureau as a public officer by not declaring some of his assets and also for operating multiple bank accounts with local and foreign currencies. Now, the tribunal ordered that Onnoghen be removed from the office of CJN and as chairman of the National Judicial Council. It also banned him from holding public office for 10 years. In addition to that, the Code of Conduct Tribunal ruled that all monies unaccounted for in Onnoghen's 5 bank accounts must be forfeited to the federal government of Nigeria. But in a swift response, the Defense Counsel rejected the ruling, saying the judgment of the Code of Conduct Tribunal is unconstitutional and did not follow due process. Take a listen now to one of the lawyers to the former Chief Justice.
The conviction is out of order, it's unconstitutional. It is a breach of fair hearing.
Yes.
Because before this day, on the 23rd of January, the same judgment had been passed before now,
Very well, correct.
removing the Chief Justice of Nigeria without a fair hearing.
Yes.
And so it was a fait accompli, it was premeditated,
Yes.
judgment had been passed before today.
Yes.
So today's judgment was just a formality.
Yes. Correct.
And
Correct.
we hold the view that the tribunal has not only breached the Constitution of Nigeria, it has breached the fundamental principles of natural justice, equity, and good conscience.
Correct.
It has not only been able to pass judgment, it has convicted for an offense that was never charged.
Yes.
Now, Onnoghen, through his lawyers, has approached the Court of Appeal to challenge the ruling of the Code of Conduct Tribunal, citing 15 grounds on why the ruling should be annulled. He is also seeking 7 reliefs at the Court of Appeal. Among them are the following: an order allowing the appeal. Second is an order that the lower tribunal lacks the jurisdiction to entertain the case. And the third, an order that the lower tribunal ought to have recused itself from the proceedings before it. And of course, the fourth is an order that the charge has become academic. And the fifth, an order setting aside the conviction of the appellant. Sixth, an order setting aside the order now for forfeiture of assets made by the Honorable Tribunal. And seventh, an order discharging and acquitting the appellant. Now, opinions are sharply divided on this issue. Joining me right now from Abuja to dissect this further is Ehioje West Idahosa, who is a legal practitioner and, of course, a former lawmaker in the Federal House of Representatives. Thank you very much for joining us on the program. We have talked about this before now, when this case went to the CCT, that's the Code of Conduct Tribunal. Of course, you opposed it at the time. Has your position changed now that there's a conviction?
Yes, I'm surprised there's one, because the position of the law is very clear on this matter. Do not forget that Onnoghen is not just a public officer, as the tribunal tried to paint. He is a judicial officer, and his species of public officers has a special provision for dealing with disciplinary matters. For example, I continue to argue that as Chief Justice of Nigeria, he is subject to judicial discipline. It is only after judicial discipline that he can now be exposed to other agencies of the law. Now, in the case of Onnoghen, the question is whether the breach of his commitment or duty to comply with the asset declaration law in Nigeria is also a breach of judicial oath. With the greatest respect, it is very clear that it is a breach of judicial oath, assuming there is a breach and without conceding. The reason I say this is that if you look at the judicial oath, one of the requirements of the judicial oath is that judicial officers must comply with the provisions of the Constitution on asset declaration. So it means that once Onnoghen fails to declare his assets appropriately, he is in breach of his oath as a judicial officer. And this is where the NJC comes to play.
But in any case, the tribunal to some extent, and even the defense in this case at some point considered that the tribunal was able to prove, and the tribunal chairman, the tribunal itself maintained that he was actually tried before the Code of Conduct Tribunal not as a judicial officer, but as a public officer. And the Code of Conduct Tribunal made it quite clear that his case is quite different from that of Justice Unguta, because do not forget that, you know, Justice Unguta's case also came to the tribunal, and the tribunal had to throw it out as a result of that judgment on Nganjiwa versus the Federal Republic of Nigeria.
Now, the difference is like 6.5 dozen. In fact, there was no difference. And I maintain that the procedure was irregular. Don't forget that the law itself is a prisoner procedure. No matter how accurate the law may be in terms of application, once you do not apply the correct procedure, you are already out of business. I say this with emphasis on the mode of arraignment. In the other one of Unguta, the tribunal conveniently said that it was banned by Nganjiwa's judgment because it had come to the conclusion that unless you first of all subject a judicial officer to the processes recommended under the NJC, you couldn't bring him before a tribunal of this nature, and struck it out. At that time, Unguta himself was also standing trial for some aspects of non-compliance with asset declaration. So what's the difference? Now, here the tribunal worked so hard to distinguish between the fact that Onnoghen was being tried as a public officer. But the question that I ask is that, as a public officer, does it mean that he's no longer a judicial officer? What do you do with the provisions of Section 292 of the Constitution? Do you waive the right of the NJC to look into an allegation of misconduct by a judicial officer and deal with him summarily or in accordance with their procedure?
But isn't it the case? Isn't it the case that look, Justice Onnoghen first and foremost was a public officer before being a judicial officer? Can that argument be made?
No, he's a judicial officer before becoming a public officer. That's the truth. He is employed as a judge, so he's employed as a judicial officer, but a judge is a public officer. So first you have to be a judicial officer.
And the fact is that the oaths, I mean, the oath now on this issue of declaration of asset that he took is not different from what other public officers actually take as well.
We agree, but I have already argued earlier on that the oath he took as a judicial officer includes the compliance with the asset declaration. So if he fails to declare accordingly, he is in breach of a judicial oath. And if he breaches a judicial oath, he has committed a judicial misconduct. And if he commits a judicial misconduct, he stops first at the NJC. If the NJC finds him guilty, they will strip him of his office as a judge and then surrender him to the appropriate agencies to prosecute him in accordance with due process. Now, if you miss any of these procedures, then you are out of business. That's my contention. It's not about whether or not substantively he made a confession, he offended the law. The question is, if a man is charged for murder, are you going to convict him without properly arraigning him? And if you arraign him, can you proceed with the trial without the man taking a plea? Can you do that? So these are the steps that go with the law. It's not a question of whether or not the man was convicted, but the processes are what guarantees the fair hearing. If you don't comply with the steps that every given officer should take, then of course you're already outside the ambit of fair hearing.
Okay, go on.
Now I was going to say, are policemen not species of public officers? They are. But there are certain laws that subject them to orderly room trial. If you accuse them of committing a crime, they subject them first to orderly room trial and then hand them over to the regular courts of the land. So we have to understand that when the Constitution says that the NJC shall have the powers of disciplinary measures over a certain category of officers, it means it. You cannot use the provisions of a schedule to the Constitution to override substantive provisions of the Constitution with respect to the removal of a CJN. Do you imagine that indeed a Code of Conduct Tribunal can recommend or order the removal of a CJN contrary to the provisions of Section 292, which talks about the mode of removing a CJN?
Let's quickly talk about the conviction now. I mean, you look at the conviction. I mean, the verdict now passed by the Code of Conduct Tribunal, first convicting him, of course, banning him from holding public office for 10 years and ordering that all the monies in the accounts that he has no explanation for should be forfeited to the federal government. What do you make of those?
Well, if you look at the provisions of the Constitution, ordinarily the Code of Conduct appear to have those powers to ban a public officer from holding public office, to get the public officer to forfeit his assets, and then, of course, to recommend his removal from office, even if he was an elected lawmaker. But the point I make is, leading to that decision must be compliance with the process.
But another question I want to ask, the fact is that Justice Onnoghen resigned before this judgment was given. Couldn't that have been taken into consideration? I mean, his resignation, for instance, doesn't it, if you like, using this word now, as you people would say, advisedly vitiate this entire process?
Well, the point is, did he resign? Because subsequent to that, his lawyer is said to have issued a statement that he didn't resign. So the story out there is that...
No, he resigned. He actually said, I mean, you look at his grounds of appeal, he did confirm in the appeal that, look, he resigned, and so if he resigned, then the Code of Conduct Tribunal has no powers to order that his assets be forfeited to the federal government. Because
and if he resigned, it is a different matter whether the authorities to whom he resigned accepted that resignation, because there is a process for resignation. He will have to resign, probably to the President of the Federal Republic of Nigeria, and then it should now be left for that resignation to be accepted. So if it's not accepted, then he remains the jure CJN of Nigeria, even if he's not a de facto CJN.
Well, but the bottom line is that no one has come out to say that his resignation has been rejected. So the assumption is that
there is a method. Silence is not consent. There is a mode for accepting official resignation. When you resign, there will be an acceptance. And all of this will have to be in writing. You can't imply resignation by body language. So let's understand that. This is not a plaything. It's a serious office. We are talking about the highest ranking.
Are you, in other words, saying that, look, Justice Onnoghen still remains the Chief Justice of this country, that there's no resignation?
I have said that his resignation, if it is not accepted by the authorities to whom he must resign, he remains the jure CJN. If I'm a public officer and I resign to the permanent secretary as a director, and the resignation is not accepted, I may have expressed my intention, but the acceptance of resignation is a sine qua non to the effective date of the resignation. So when you say he has resigned, what is the date of that resignation? The date will be the date upon which the resignation was accepted. In this case, there has been some silence. Neither the executive nor anyone else from the other arm of government has talked about that. But Onnoghen maintains that he has resigned. But as I said before, that's a matter for construction.
And just as there have been a prolonged silence over the decision of the NJC on Justice Onnoghen. I mean, the NJC is not saying anything. Nothing is forthcoming from the executive and the presidency. And the NJC says it has actually made its recommendations to the president, but nothing forthcoming from both sides. Isn't that worrisome?
Yes, the NJC may have been boxed into secrecy. Don't forget that before they could say Jack Robinson, Onnoghen himself had been rushed to the tribunal. So it could be that the NJC did not want to prejudice the trial of Onnoghen going on in the tribunal. It could also mean that the NJC did not want to escalate matters. So they may have resorted to making their findings quietly and trying to hold on to their findings pending the outcome of a tribunal which had commenced the trial of Onnoghen, albeit without the recommendation of NJC.
But how do you see this playing out eventually? Because Justice Onnoghen has actually headed to the Court of Appeal. He's filed a motion for appeal, appealing on 15 grounds.
Yeah, the law says that when there is a decision by the tribunal, whoever is affected has a right of appeal to the Court of Appeal as of right. So Justice Onnoghen does not need the leave of the tribunal to go to the Court of Appeal, and so long as he has filed his notice of appeal, which is now in the public domain, we can now conveniently say that an appeal has been filed. As soon as the records of the tribunal are compiled and sent to the Court of Appeal, then we can say an appeal has been entered, and then we wait for the arguments of both sides and hope that the Court of Appeal can resolve this matter against the background of its own substantive judgment of the Lagos Division in the Ngajiwa case, which was very expansive and which did not try to distinguish between a public officer serving as a judicial officer or a judicial officer classified as a public officer. It was a holistic decision, and as you do know, at the end of the day, the law is what the judge says, period.
Absolutely. I mean, interesting days ahead, no doubt. Thank you very much, Honorable Ehioje West Idahos. I call you honorable because I understand once an honorable, always an honorable,
Always.
right?
Thank you very much. I appreciate this.
All right, thank you very much for your time. We'll take a short break now, and when we come back, we'll have another legal opinion on this controversial issue, if you like. But no doubt, it's just not the end of the road on this. We're all watching and looking at how the appeal court decides on this case eventually. And there's a possibility that it might head to the Supreme Court. But then we'll take a short break, and we'll be right back with another legal opinion. On Deji 360, we don't just ask the questions. What is wrong with amending the Constitution the way the National Assembly members have been doing it? We seek answers.
Constitution is constituent.
Our problem is not lack of laws. Our problem is lack of the willpower to implement our laws.
Answers that provide clarity.
While we negotiate, we should try to make it a point that the girls must be complete.
The clarity you need to make informed judgment so that you can make the right decision and take action. People are saying it is you politicians that are responsible for this, that you are the reason why this is happening.
All these dollars that call themselves governors in this country?
I wish we had people like Tony at the National Assembly.
God forbid that I go to join that ballot.
Deji 360, providing clarity to issues.